Uh,
The intent to deceive recommendation that you put forward?
Yes, certainly. And again, this is being provided to the committee in a brief, so you should be able to review it there as well. Currently, there's a proposal in the legislation to have an offense, a criminal offense, for failing to provide FINTRAC information or providing incorrect information to FINTRAC. We don't have a problem per se with the offense, but as with many fraudulent offenses under the criminal code, fraudulent statement offenses, there's an intent to deceive. What we wouldn't want here is an unintended consequence where someone in good faith has, through an examination process, let's say with FINTRAC, decided to provide certain information in response to FINTRAC. Perhaps the information, in their view, was correct, or perhaps it was not needed. They failed to provide information because it wasn't simply needed based on their good faith judgment. We wouldn't want a criminal censure to be placed against a good faith action by a compliance officer in an organization. The unintended consequence is you can impact both the hiring and retention of high quality staff in this important area in the bank.
Okay, thank you for clarifying that. I was wondering, Mr. Donovan, Canada has seen a huge rise in online gambling in recent years due to legislative changes that have really opened up this market. Have you been seeing any related rise in money laundering in relation to online gambling activities?
The scope of what we're here to speak about on Bill C-12 is really looking at the provisions that we've talked about in our opening address in the brief. In terms of seeing an increase in money laundering in the gaming sector, I think that might be a better question directed towards FINTRAC, who receives the information from the gaming sector and other sectors related to suspicion of money laundering coming from those areas, and they would probably be in a better position to answer that question.
So are you saying you can answer the question, or you just won't answer the question?
I don't have the information to be able to accurately tell you whether or not I've seen an increase or not.
Okay,
again, I think it's better to go to FINTRAC for that information.
There was people who were significantly concerned about provisions that I see have now been included in Budget 2025 about banning cash transactions over $10,000. I was wondering if you could provide maybe some context for people about these provisions and why these provisions have been brought forward, and can you provide some more information about those?
I can't speak to Bill C-12 at the moment. Bill C-2. We're here to speak to Bill C-12. I can certainly follow up with your office if that would be helpful and connect you with the CBA. But it would be inappropriate for me to comment on the decision of the government around certain amendments.
How do you think the legislative changes in Bill C-12 will affect law enforcement's ability to investigate complex financial crimes that are related to organized crime?
The majority of changes in Bill C-12 are related to supervision and compliance. That's really the focus of these changes. And, I can't comment necessarily on external factors, but I can indicate, I think, comfortably that the changes we're suggesting, the minor amendments we're suggesting to Bill C-12, would help to create more predictability and transparency around those supervision and compliance powers to ensure a more efficient and effective regime, which ultimately does help to empower the AML
I've only got a minute
regime.
left. Are you familiar with specifically Parts 9 and Parts 10 of Bill C-12? And do you think that these are sufficient to address the current vulnerabilities that criminal organizations are exploiting within the financial sector? Or do you think stronger and clearer legislation is needed?
I think that, we're supportive of a strong AML regime that's efficient and effective. And particularly, we believe if minor amendments are made to Bill C-12 along the lines that we've outlined in the brief to the committee, that they'll likely strengthen the regime and lead to better protection for Canadians.
Thank you, MP Lloyd.
Thank you to the witnesses for coming here today and testifying. I want to start with my first question. So could you outline the expected financial impacts of Bill C-12 on financial institutes, particularly in light of the bill's significant increase on compliance obligations?
I can't speak to, it would be inappropriate for me to comment on the individual impacts on a member. I don't have line of sight on that level of spend. But what I can say, I think, is, to answer your question, is that the changes that we see, these technical minor changes that don't substantively change the bill, will drive efficiencies and effectiveness, and so will help to ensure that implementation is efficient and effective, which overall means that more resources can be focused on targeting risk and protecting Canadians.
Okay. So given the heightened obligations introduced under Bill C-12, do you foresee a realistic possibility that the increased compliance costs could be passed down to the consumers? For example, I'll give you the higher service fees, reduced service availability, and things like that.
I can't I don't have line of sight on what an individual institution would choose to do. Again, I think our goal is to create the most effective and efficient AML regime to ensure that bank resources, are focused on risk and providing key intelligence to FinTrack and detecting, deterring.
Can you say
laundering.
anything about, in addition to any costs being passed down to the consumer?
It would be inappropriate for me to comment.
Okay, thank you.